Good afternoon, everyone. Thank you for joining this initial first session on online inquest training that we're undertaking. You can see from this first slide, we've got a series of three sessions that we're covering for inquest. It's a massive topic, a massive area. So we've tried to break it down into three distinct areas which will be of note, to be honest. So I'm covering today's session on the coronial system. It's some background information, and more importantly, towards the end, I'll be covering the guidance note from the Chief Coroner in light of COVID-19. Next week's session will be dealt with by John, dealing with conclusions and Article 2 inquests, and the final session by Lucy on the 20th of May on the evidence required at hearings and Regulation 28, more about later. We see an image here, cartoon image taken from the 19th century, an inquest in the 19th century. We're really far from the depiction within this photograph, within this sketch. For those that can't read the caption on the bottom, the juror asked the coroner is the man in the wig. Sir, the man's alive, sir, for he has opened one eye. And the coroner's response being, sir, the doctor declared him dead 2 hours since, and he must be dead. So I shall proceed with the inquest. So fortunately, we have advanced significantly, both scientifically and in terms of safeguards since this image was taken or depicted in the mid-1800s. What about this? Some of you may have watched the BBC drama, The Coroner, viewed a couple of years ago. I think it screened in 2015, 2016, in a picturesque setting in Devon. Unfortunately, the series, despite having some good ratings, got axed after series 2. But did that really show the work of a modern day coroner? Probably not. So, you know, the images that we see on TV, we can probably put that to the back of our mind in terms of what the role of a coroner entails. In terms of the coroner's powers and duties, these are now contained within a statutory framework of the Coroners and Justice Act 2009. The whole coronial system is now headed by a Chief Coroner who has judicial oversight over the whole coronial system, and whose main responsibilities are to really set national standards, develop training, approve future appointments, keep a register of investigations lasting more than 12 months, collate, monitor and publish coroner's reports to authorities to prevent future deaths. One of the other aspects is clearly monitoring, publishing annual coroner's reports to authorities to prevent other future deaths. We do, to interact with our audience here, what I'm going to do today is throughout the series of slides, introduce some questions that the audience, the attendees can introduce. So I'm going to ask my marketing assistant just to bring up the first poll, Gabs, if you don't mind. So we've got the first poll here asking approximately how many coroners are there in England and Wales, and if you can just respond, and then I can sort of feedback what your results are. Second question, what's the mandatory retirement age for coroners? And we've got a third question there. What type of systems does the Coronial system operate within? Let's share the results. So question 1, how many coroners are there in England and Wales? The majority opted between 98 and 109, 29% each. Some said 210, and 6 of you decided 55. In actual fact, there are, at the time I conducted the poll, there were 98 coroners in England and Wales. I did have a look this morning on the government website to check whether that figure had changed. So the people that had actually suggested 109, you're not far off neither. So it's actually 104 coroners in England and Wales. They are approximately 109 coroner areas which loosely mirror the boundaries established by local authority districts. Local authorities or coroners employ coroners' officers to assist them with their investigations. Just let's have a look at the second one. I'll stop sharing the poll. What's the mandatory requirement age for coroners? This is an anonymous poll, so your names are not displayed, so there is no right and wrong answer here. The majority got this second question right. The answer is 70. There is a mandatory retirement age of 70. And I'll come on to more about that in terms of historically how it operated. And the third question, what type of system do we operate within? And again, the majority got that right. It is inquisitorial. So, you know, well done to everyone. But for those that don't know, I'm going to explain the reasons for that. Close that. Yeah, so basically, coroners employ coroners' officers to assist them with their investigations. Under the 2009 Act, there has been a hierarchy of coroners. So you may have come across the terms senior coroners, area coroners, and assistant coroners. Effectively, it's in that hierarchy. Historically, local authorities appointed coroners, and deputy and assistant coroners were then appointed by the senior coroner with the local authority's approval. However, since the 2009 Act, local authorities are now responsible for all coroner appointments, but they must seek the consent of the Lord Chancellor and the Chief Coroner to the appointments. There is a greater transparency and greater expectancy of standards across the board as far as coroners are concerned. Under the 2009 Act, all newly appointed coroners had to be legally qualified. Historically, you could be appointed as a coroner as a lawyer or actually as a doctor, a medical practitioner as well. That is no longer the case. In terms of working hours, well, coroners actually are required to work 24/7. They need to make themselves available to undertake urgent matters which cannot wait until the next working day. This might arise in circumstances like religious burials, as an example, at the weekend, but the coroner is contactable or should be contactable at all times. As the poll indicated, there is a mandatory retirement age at 70. Again, historically, coroner posts were considered posts for life. In some instances, the coroner legacy went through family generations. That's certainly not the case anymore. Local authorities actually have a responsibility for funding local coroner services. Whatever officers and other staff are needed by the coroner's court for that area to carry out their function. Actually, local policing bodies also provide officers and staff to assist the coroner's office. Coroners can delegate administrative but not judicial functions to their officers and support staff. It's a change which arose following the Shipman inquiry. Officers dealt with queries from, one of the learning points from the Shipman inquiry was officers actually dealt with queries from doctors in relation to some of the Shipman victims, and advised the coroner that the coroner wouldn't be interested in a particular death without necessarily consulting the coroner. As a safeguard, coroners have to be aware of all deaths and make the decision whether or not to carry out an investigation, more about which I will speak about later. The aim of the coroner's court is not to frame any conclusion to determine civil or criminal liability. Sometimes for those that have been involved in inquests and attending the coroner's court, it does feel essentially like that there is some, blame going on here. That is what the coroner's court is trying to aim at, but that's certainly not within the remit, the statutory remit of the coroner's court. In terms of conclusions, that's something that John Miles, as I mentioned earlier, is going to deal with during the course of session 2. If you are a witness, there is a right not to self-incriminate, and usually coroners would give a warning to witnesses where there is a risk of this. Again, as we've touched in the poll, the majority are right. This is an inquisitorial system. It's led by inquiry. It's not adversarial, and what we mean by that is the adversarial systems are systems such as the criminal and civil courts, where you have two parties. In the criminal courts, you have the Crown prosecuted via the Crown Prosecution Service, and you have the defendants. In civil courts, you have claimants and defendants. We don't have that system within the coroner's system. In terms of guidance that the coroners must have regard to, they must have regard to legislation and information which are listed here. So you've got the legislation, the 2009 Act, which actually came into force on the 25th of July 2013. From this date, actually all investigation, including deaths which had already been investigated, were dealt with under the new regime. More recently, we've also had additional legislation, such as the Coronavirus Act 2020, which was granted royal assent on the 25th of March 2020. That specifically actually is relevant to COVID-19 circumstances, and I'm going to deal with that later on. There are, to date, 37 guidance notes issued by the Chief Coroner, which 4 of which were actually provided during the course of this pandemic. And again, I'm going to deal with that later on. The guidance notes actually are there to provide, as it says in the title, a guide to coroners to promote some consistency amongst the courts, coroners' courts, and to really deal with issues that are likely to arise during the course of an inquest, whether that be post-mortem examinations, the use of translators, conclusions, jury inquests, hearsay evidence, reports to prevent future deaths. So it's a guide. There's also information or guides regarding media attendance at coroners' hearings and reporting on inquest matters. So this is the main bulk of the legislation that the coroners would have regard to. Just some statistics as part of the Chief Coroner's Guide. He does publish annual statistics. The statistics are published in May. We don't have the 2019 stats as yet, but the data we have for 2018 show that 220,600 deaths actually were reported to coroners, the lowest level since 2000. One of the key reasons for this was the deprivation of liberty cases were removed from having to be reported to coroners. There were 513 deaths in custody, which was down from 521 in 2017. So a downward spiral, but still pretty high. 85,600 post-mortems ordered by the coroner. The average time for a coroner's inquest between 21 and 26 weeks. One of the remits of one of the issues raised within the 2009 Act was any inquest taking longer than 12 months had to be reported to the Chief Coroner, who publishes all cases lasting longer than 12 months. I can tell you, having looked at this, the earliest live open inquest dates back to 2003, so quite a while ago, and that's an open inquest. Many reasons for this, including investigations by external authorities, current criminal proceedings, deaths abroad, complex cases. There are approximately 1,200 cases which haven't been resolved or 12 months or longer. We would expect the 2019 stats to show a similar downward spiral or trend as people live longer due to health and technological advances. We will publish up-to-date figures. They are imminent within the next day or two. Certainly, the current pandemic is likely to buck that downward trend, certainly in next year's statistics. In terms of Coroners Investigations, the 2009 Act introduced a new concept of what's termed investigation into a death. Actually, much of the coroner's work actually takes place before the formal inquest hearing. A coroner's duty to investigate a death actually arises in certain circumstances, which are set out on the slide here. Clearly, the body has to be within the coroner's area, and more importantly, the reason to suspect that the deceased died a violent or unnatural death, the cause of death is unknown, or thirdly, the person died in custody or state detention. What do we mean by state detention? Well, it is defined by the Act, and it really means any person or a person who is compulsorily detained by a public authority within the meaning of Section 6 of the Human Rights Act. This, in effect, does extend the definition of state detention to immigration detention centres, secure mental health establishments or hospitals. Actually, all deaths in custody or state detention must be investigated and go to inquest, but not necessarily always with a jury. More about later. In terms of the purpose of an inquest, inquests are legal inquiries into the cause and circumstances of a death. They are limited to fact-finding inquiries. A coroner will consider both oral and written evidence during the course of an inquest. But in terms of the actual statutory questions that the coroner is tasked with, these are limited to who the deceased was, when, where, and how the deceased came to his or her death. In Article 2 inquests, the question of how is treated actually quite broadly, because it will actually include establishing in what circumstances the actual deceased came to his or her death. John's going to deal with that in more detail in session 2. Inquests are public hearings, can be held with or without juries. Both are equally valid. Coroners are required to complete an inquest within 6 months of the date of which the coroner was made aware of the death, or as soon as reasonably practicable. That time limit is likely to be relaxed in light of COVID-19. More about later. The last point here, the coroner can, at the conclusion of an inquest, also make recommendations to organisations in relation to action he believes or considers they should be taken to prevent future deaths. Again, I'm not going to go into too much depth in relation to that, because that's something which Lucy is going to deal with during the course of session 3 in terms of regulation 28. These are some terms that you'll come across if you're involved in inquests or requested to attend. Interested persons. So I've got 4 questions up here. Who can be considered to be an interested person? The rights of an interested person, the entitlement to documents, and the ability to address the coroner on points of law. So I just want to deal with those specifically. Interested persons actually refer to someone's right to actively participate at the inquest, whether by virtue of their relationship with the deceased or their involvement in the circumstances of the death. So it can include family members. It can include any beneficiary under a life policy or an insurer who issued that policy. Any person or organisation whose act or omission may have caused or contributed to the death. It can include an enforcing authority, such as the Health and Safety Executive, the CQC, or any other person who, in the opinion of the coroner, has a sufficient interest. The coroner has actually a discretion to appoint anyone as an interested person or party upon their submission to give evidence if requested to do so. An interested person can ask questions of witnesses called by the coroner and address the coroner on points of law, but not the facts. They are generally allowed to see documents before the tribunal. So that, if you're called as a witness, you're probably not entitled to do any of those aspects of what an interested person can do. So it's a really important status as far as the coroner's court is concerned. We have here on the right a typical coroner's room. What we do know is coroner's inquests are held in public. Both the public and the media have a right to attend. Inquest should be completed within 6 months from the date the coroner is made aware of the death, or as soon as reasonably practical thereafter. It is usual in complex cases for a coroner to actually hold what they called a PIR, a pre-inquest review. These are important for various reasons. Really, it identifies key areas, and it enables certain interested parties and their representatives to really get a feel for the coroner, for the coroner, for the avenues the coroner wants to explore during the course of these inquiries, and issues that are likely to be raised during the course of an inquest. At those PIRs, they normally deal with issues such as the identity of interested persons, the scope of the inquest. Is Article 2 engaged? Is a jury required? Are any further matters actually needed in terms of investigation? Normally, a list of witnesses, both factual and expert, are provided. Disclosure by the parties are dealt with at PIRs. A jury bundle is normally dealt with at that, who's going to be responsible for that, and what should the bundle actually contain. The date for the inquest, how long it's going to take, and the venue and legal submissions as well. In terms of the conduct at such hearings, coroners, because it's his court, it's his investigation, will ordinarily always ask questions first. Interested parties will get an opportunity after the coroner has asked questions. As I've mentioned before, coroners, they can't be addressed on matters of fact, but interested persons can make submissions on the law to the coroner. There can be sometimes there can be requests for reporting restrictions. Lucy's going to cover that. Again, there is a recent case where such an application was made, but she's going to deal with that during her session on evidence. These are formal hearings, but coroners are often very sensitive to the fact that the deceased family are often present. There's some expectation that the inquiry is held without necessarily upsetting the family. They often want answers. They will come to inquest hearings wanting answers about the death of their loved ones and the circumstances as to how that came about, whether it was as a result of an act of omission, for example. They don't always get the answers. They want, but the coroner has to balance basically their interests with the interest of safeguarding the judicial function that he has been set up to basically undertake in establishing the 4 statutory questions that we've covered earlier. For those certainly involved in criminal and the civil courts, one thing you won't be seeing the coroner do is wearing a wig. So fortunately, I'm not going to be donning that today. Again, we have a depiction from the 19th century here, a jury. Fortunately, the juries of today will look far different to what is shown within this image. You may still get a juror who's bored, others clearly not wanting to be there, but often the majority of jurors take their civic duty responsibly. I do have a poll question at this stage, Gabs, if you don't mind. So again, this is an anonymous poll. So the question is, what is the minimum requirement for a jury to be valid? %, voted so far. Come on, the last 10%, you can do it. Just waiting for the last 10% of people to vote, so last couple of minutes. A few seconds, hopefully. We'll leave it at that. The majority voted for 12. Whether it's because there's 12 jurors in the picture that I've shown, I don't know, but 46% of you voted 12, 22, 11, 22, 9. Actually, the minimum number of jurors required for a jury inquest is actually 7, between 7. So the minimum is 7. So if you got between 7 and 11, you opted for that, you're right. 5 is far too low, so good result there. So the answer on that is 7, minimum number. Let me just stop that. Gabs, do I get rid of that? Brilliant. Just talking about jury trials. Section 7 of the 2009 Act sets out really the circumstances in which an inquest will include a jury. There are limited circumstances where a coroner actually needs a jury, needs to hold a jury inquest. So coroners will ordinarily order a jury inquest where there's a death in custody or state detention, and the death was violent or unnatural or the cause unknown. But the death arises from the involvement of the police as well, and for certainly the majority may have been involved who have either attended where there'd been a jury inquest. It's where the death was caused by a notifiable accident, poisoning or disease, which means it's reportable to any government body, inspector, so that can include the Health and Safety Executive or the CQC, for example. In terms of, I'm going to talk about jury inquests more about in relation to the guidance, in relation to COVID-19, because some of you will have spotted, obviously, there's a possibility that COVID-19 may be deemed to be a disease, and as such, would an inquest be held with a jury, and I'm going to deal with that later on. Actually, coroners do have a wide discretion that they have to exercise judicially. Usually interested persons are afforded representations at a pre-inquest hearing to actually make submissions as to whether or not a jury inquest is necessary. You often find families will want a jury inquest, but that's not necessarily always the right decision for all such cases. So in summary, really a coroner will normally be required to summons a jury where circumstances point in the direction which I've touched upon. Accident and the accidents not work related. There's also wide discretion given to the coroner as well to hold an inquest where, and the Act talks about where there's sufficient reason, so a pretty wide discretion there. I'm not going to spend too much time over the next few slides, but these slides will come out to you, but there's a really good flow diagram which, for those involved in inquests or having to attend, these are some good slides, a good flow diagram that it's worthwhile being familiar with. It's actually been designed by the Judicial College to assist coroners. It provides a really helpful overview of the decision-making options available to a coroner. So that's the overall picture of the whole process. It's broken down into several phases, and I'm just going to touch upon that individually. We have a pre-investigation phase where the deceased actually died of natural causes. It's not necessary for the coroner to carry out or conduct an investigation following the initial reports, and no further action is taken. So a pretty straightforward option there. Another phase where an investigation is taken, but the decision options lead to the steps taken leads to the decision not to proceed to an inquest hearing. So this slide really sets out the flows or the options available to the coroner in relation to that option, investigation with no inquest. And finally, the third option, which is an investigation which leads to an inquest. Here you have the options where either a post-mortem's undertaken or there's no post-mortem undertaken. The cause of death is established, but the coroner still considers it necessary to proceed to an inquest hearing. There are circumstances where a coroner can actually suspend an investigation because of ongoing criminal investigation, such as corporate manslaughter, CQC investigations, HSC investigations, where the coroner considers it appropriate to do so. So I'll send, I'm not going to spend too much time in relation to those slides. They will be sent out, but it's worthwhile having a look at that if you are involved or having to attend an inquest. Finally, some of you may be wondering what this picture shows. Well, another role of a coroner is not simply to investigate deaths. It actually extends to investigating and declaring whether a find amounts to treasure. And this is treasure from such a find. From the statistics produced by the Chief Coroner, this is a map of finds, treasure finds in England and Wales. So if you're a coroner in Norfolk or the South Coast, you're a coroner with a pretty busy inquest practice. For those in the Northwest, unfortunately, not such a busy treasure find. I do have a further poll at this stage. Gabs, if you can do the honours. So 2 questions here. In 2018, how many fines were reported to the Coroners Court in England and Wales? And the second question there, how many of those fines resulted in treasure inquests? Sorry, third question as well, how many treasure inquests resulted in a conclusion of treasure? So I'll give you a few minutes just to have a look at those questions. I'll give you last 30 seconds for those that haven't voted, just to put your options in. Like the majority of you, question 1, you went for 500 fines reported to the Coroners Court in England and Wales. In actual fact, in 2018, there were 999 fines reported to coroners, 60 less than there was in 2017. So those that 18%, 6 of you who chose 999, completely correct. Second question there, how many of those fines resulted in a treasure inquest? The majority went for 140 and 29% of you chose 425. The correct answer, actually 425 inquests were concluded into fines. So it's 425 there. Of those, in terms of the third question there, the majority went for how many treasure inquests result in a conclusion of treasure. Majority went for 76% of you. Surprisingly, the answer is 380 of the 425 inquests returned a verdict of treasure. So, interesting exercise there. Thank you for that. That's all really I want to say at this stage in relation to the role of the coroner. I want to move now on to Coroners Guidance in light of COVID-19. Since the government lockdown over a month ago, there's been certainly a flurry of Chief Coroner Guidance on how coroners need to deal with inquests, hearings, whether COVID related or not. What I'm going to do is briefly look at 3 of the 4 guidance notes over the next few slides. So the first guidance note was on the 26th of March, a day after the royal assent was given to the Coronavirus Act 2020. The Chief Coroner issued a guide, really mostly dealing with practical matters which most of us have come accustomed to. So, for example, no physical hearings unless it's urgent or essential business. Civil courts have similar guidance and procedures in place. Remote hearings to take place where necessary, but the coroner had to physically be in court because it's a public hearing. The media had a right to be notified and to be present and to be notified of inquest hearings as well. The guidance also encouraged the use of paper documentary inquests, which is termed or used, the term used is Rule 23 inquests. These are essentially fast-track inquest hearings if certain conditions are met. So they're dealt with by the coroner looking at witness statements or documents. Mindful of the pressures that health professionals are under, the Chief Coroner also advised that, for coroners to be aware of this, certainly in relation to the use of post-mortem investigations and where pathologists have to undertake those inquiries. So a bit of guidance from the Chief Coroner about Chief Coroners being, or coroners being mindful of those issues. In addition to that, Guidance Note 34 on the issue of the coroner's duty to investigate under Section 1 also reminded coroners that in a hospital death scenario, establishing COVID-19 as a cause of death and following the medical certificate cause of death process was a relatively straightforward matter, because you've got the diagnosis and treatment in life there, and any medical practitioner can actually certify COVID-19 as the cause of death. It also recognised that there were many community deaths as well, and that was, making the whole process a lot more complex. Because of the pandemic pressures, there may have been insufficient capacity within the health service itself, and we've seen that, to actually diagnose COVID-19 as an illness in life. And so it allowed medical practitioners to produce the medical cause of death certificates after death without any report, without reporting it to a coroner. What the guide also goes on to say in terms of the coroner's duty to investigate is that a death as a result of COVID-19 is not on its own sufficient to make a referral to a coroner. It's a notifiable disease, but that doesn't necessarily mean it needs to be referred to a coroner. So another reminder there. And a final point there being, it's a naturally occurring disease, a natural cause of death, and therefore it's not unnatural, it's not an accident. And in those circumstances, really narrowing the medical practitioners who are certifying deaths, referring COVID-19 cases to coroners for investigation. And really a reminder for coroners as well that if those cases have been referred to them, what they should be doing in those circumstances. We've then got Guidance Note 36, issued 4 days later, the first guidance note. It really summarised the Coronavirus Act in terms of the impact on the work of coroners. Specific references really made under Section 30, which removes the requirement for an inquest to be held with a jury, where the reason to suspect death was caused by COVID-19 and the coroner decides to open an inquest. This was also another reminder that COVID-19 deaths should not automatically be referred to the coroner for investigation. That brings me on to the last guidance note in my last 2 slides, where last week the Chief Coroner issued yet a further guidance note to coroners on COVID-19 deaths and possible exposure in the workplace. It doesn't need me to tell you that this has been on the agenda for months throughout the duration of this pandemic, and regarding the availability and suitability of personal protective equipment. First raised in Parliament in January 2020. The government have offered frequent bulletins on the volume of equipment being delivered over the last few months. There's been highlighted focus, certainly, and concerns on the increasing number of deaths affecting critical frontline workers, whether that's within the NHS, public transport, or even within care homes. Families of the deceased usually want answers from a coroner on whether an organisation, policy and procedures could have prevented the death of their loved ones. were there failings from the coroners from employers in providing PPE, which has contributed to the death of their loved ones? Really, in light of the media scrutiny and competing complaints from trade unions, organisations, leading professionals, and frontline staff themselves, it was inevitable that the Chief Coroner felt it necessary to issue a further guidance note to coroners in order to ensure the coronial system was not overwhelmed with COVID-19 inquests. So where the deceased has worked on the front line and there was possible exposure to COVID-19, what the coroner has highlighted in terms of, is there a requirement to report to a coroner if the same matter has been reported to the HSE under the RIDDOR requirements? Just really touching upon that. I've already touched upon that COVID-19 is a notifiable disease. It has to be reported to Public Health England and the equivalent in Wales. The HSE more recently actually issued some guidance and said, actually, COVID-19 is a biological agent and therefore has to be reported as part of their RIDDOR requirements. There's some instances, and the Chief Coroner identified this, where COVID-19 deaths may have to be reported to the coroner, such as where the virus may have been contracted in the workplace setting, and notable examples being where this type of disease had been previously reported. Mesothelioma cases, which is a workplace exposure to asbestos, falls within this category. So the Chief Coroner does identify there are some instances where COVID-19 deaths may be reported to a coroner, but he goes on to note that first, the coroner has to consider whether they actually have a Section 1 duty to investigate, and those I've touched upon previously. The guide actually says, if the medical cause of death is COVID-19, there's no reason to suspect any culpable human failure contributed to the particular death. There is no usual requirement for an investigation to be undertaken by the coroner. It goes on to also say, in those cases where there is reason to suspect some human failure contributed to a person being infected with the virus, then an investigation inquest may be required. However, in those cases, a coroner would need to decide whether any failures or precautions in a particular workplace caused the deceased to contract the disease, the virus, and contributed to their death. In terms of medical causation and legal causation, this is going to be a real difficult exercise to establish that a particular work setting caused the deceased to contract the virus, given the pandemic nature of the virus itself. It's really an interesting legal question for another day. So, a lot of questions there. A final reminder towards the end of that note, of that guidance note, is by the Chief Coroners that the scope of an investigation is for individual coroners in the context of answering the 4 statutory questions. It reminds them that inquests are not the right forum for addressing concerns about government policy or public policy. Many legal commentators have said that this essentially puts a nail in the coffin, pardon the pun, insofar as families using coroners' courts to address perceived failings which may have contributed to the death of their loved ones. What is not being said, that employers do not have a duty of care to their employees to provide adequate and suitable PPE, welfare facilities, or to ensure social distancing in the workplace if they are essential to the business and need to attend. It simply says the coronial system is not the arena to voice those concerns. Those issues are more likely to be pursued as part of a civil claim if such a claim was pursued. Whilst the government recently announced a compensation payment of £60,000 for frontline health workers who have died as a result of COVID-19, this is really likely to be insignificant if, for example, a civil fatal claim was brought under the Fatal Accidents Act and there was a dependency claim. Certainly experience tells me that compensation payments would be significantly higher under that act, but again, that really is a topic and discussion for another day. I think that's really the end of what I wanted to cover in this session. Due to the time restraints, I don't think we had time to ask questions via the chat, but I've put my email address here, and so please feel free if there's any issues you really want me to cover, which I've covered today, or want to ask me any questions which arise, then please feel free to drop me an email and I will aim to respond to those prior to next week's session. Thank you for attending.